This is a review of Unit 2 of AP U.S. Government and Politics entitled Civil Liberties and Civil Rights. The first distinction that AP U.S. Government students would have to make in this unit is the difference between a civil liberty and a civil right. A civil liberty is defined as something that protects individuals from their government. It actually pushes the government away and prevents them from intruding into your personal life. Things like the amendments inside of the Bill of Rights would be considered civil liberties because they give us protection from our government. Meanwhile, civil rights are actually things that the government does to actively promote our equality. Laws passed by Congress to give us a level playing field would be considered civil rights laws. The First Amendment to the U.S. Constitution is a prime example of something that gives us very specific civil liberties. Of the 5 freedoms granted to us in this amendment, AP U.S. Government students need to be most familiar with the freedoms of religion, speech, and the press. Let's begin with freedom of the press. Access to free and open media outlets is critical for any democracy. There are 3 Supreme Court decisions relating to the freedom of the press that most AP U.S. Government students would need to know for the AP exam. The first of which is Neer v. Minnesota, a case in which the Supreme Court ruled that prior restraint, that is, censorship prior to the release, cannot be utilized in most cases by the government. The second is Schenck v. the United States. This was a case in which the clear and present danger clause was established. Any written works that create a clear and present danger to the American people can be censored by the government. Finally, in Hazelwood School District v. Kohlmeyer, the Supreme Court ruled that school or curriculum-based newspapers have a lower standard for the First Amendment and could be censored by school administration, depending on the content. But what about speech that is untrue and designed to hurt someone's reputation? This is known as defamatory speech because it's designed to defame someone's character. Slander and libel are 2 forms of defamatory speech. Slander is when someone makes an untrue statement about someone else by mouth with the intention of hurting their reputation. Libel is when the same act is committed, except it is done in writing. But what about if the person is a well-known public figure or a celebrity? Well, the Supreme Court has actually ruled that the standard is a little bit different when it comes to public figures. In the Supreme Court decision of New York Times Company v. Sullivan, the Supreme Court ruled that in order to find someone guilty of libel when it comes to a celebrity, there must be proof that the author of the article had malice. Malice would be the direct intention to do ill will or cause harm to that celebrity's reputation. Now on to the freedom of speech and expression. Of course, speech comes in various forms, and not just the traditional type of speech that we would think of. There's also what's known as commercial speech, which is the type of speech that goes out over public airways like radios and televisions. This type of speech is monitored heavily by the Federal Communications Commission, or FCC. This is, of course, a regulatory agency that works in the executive branch. And what about speech that is considered offensive or obscene? In the Supreme Court case of Miller v. California, the Supreme Court ruled that obscene speech is defined by community standards. In particular, the speech would be considered obscene if it shows no artistic value to the community. Of course, some speech comes without any words at all. This is what we refer to as symbolic speech. There are 2 prominent symbolic speech cases that AP U.S. Government students should know. In Tinker v. Des Moines, a peaceful student-led protest was led over the Vietnam War with the use of black armbands. The Supreme Court ruled that this student-led protest was peaceful and thus protected by the First Amendment. AP U.S. Government students should also know the case of Texas v. Johnson, which established the idea that burning the American flag is still considered a form of free speech. Finally, let's look at the freedom of religion. The freedom of religion inside of the First Amendment is actually broken down into 2 different and distinct clauses, the first of which is known as the Establishment Clause. This is the idea that the U.S. government is not permitted to create a national or state religion that all of its people must abide by. There are several Supreme Court decisions that relate to the Establishment Clause that students should know for the AP exam, the first of which is Engel v. Vitale. In this case, the Supreme Court ruled that school-sponsored or mandated prayer was a violation of the First Amendment's Establishment Clause. Also the case of Lemon v. Kurtzman that said that any government money or funding that goes to a religious school must be going for a non-religious or secular purpose. The other clause that pertains to the freedom of religion is called the Free Exercise Clause. This says that citizens should be permitted to practice the faith of their choosing so long as they do so within the legal boundaries. Legal boundaries is a key term here, as one of the cases that students should know is the Employment Division v. Smith, in which a religious group tried to justify its use of an illegal drug as part of its freedom of religion. the Supreme Court ruled that the use of illegal drugs violated the already in place statutes and thus could not be considered free exercise of religion. A phrase that often comes up when it comes to the topic of religion is the wall of separation. In modern political terms, you may hear it referred to as separation of church and state. It is important to know that these words were not written anywhere in the Constitution, but in fact, they were part of a phrase that was first coined by our third president, Thomas Jefferson. The idea of the wall of separation is that there should be some type of division between religious beliefs and policy making, and that the two should not cross or influence each other. Continuing our look at civil liberties, let's next look at the Fourth Amendment to the U.S. Constitution, which clearly protects us from unreasonable searches and seizures by the government. It also clearly states that in order for a law enforcement official to obtain a warrant, that official must obtain probable cause to do so. It is important that students have a clear distinction between probable cause and reasonable suspicion. Probable cause is when someone has actually seen, heard, or experienced something that certainly makes them believe that there is reason to conduct a search. This is the legal burden that any member of law enforcement must have in order to obtain a warrant and conduct a search. On the other hand, reasonable suspicion is just the inner belief that something wrong has been done. The Supreme Court decision of New Jersey versus TLO actually established that school employees and administrators only need reasonable suspicion to conduct searches. However, a member of law enforcement would still have to obtain probable cause. Conducting searches for members of law enforcement has a very strict set of rules with which they must abide by. The exclusionary rule is certainly one of those rules. The exclusionary rule actually says that any illegally obtained evidence cannot be used against a defendant in a court of law. The case that established this precedent was the case of Mapp v. Ohio. It was extended even further in a case known as Katz v. the United States, in which public recordings and wiretaps were also ruled to having being applied to the exclusionary rule. Next, we'll take a look at the Eighth Amendment to the Constitution, which protects us from excessive fines and bails being imposed on us, and particularly from the infliction of cruel and unusual punishment. The debate has raged on for decades between liberals and conservatives in America about whether or not capital punishment, that is, the death penalty, is cruel and unusual punishment. The fact is that the death penalty is regulated by the individual states, with some states still using it and others not using it any longer. It is still permitted for high federal offenses in federal courtrooms. In the case of Gregg v. Georgia, the Supreme Court actually ruled that the death penalty is constitutional, but should only be used in the most extreme set of circumstances and cases. Outside of the first 10 amendments in the Bill of Rights, by far the amendment that U.S. government students should know the most is the 14th Amendment. That is because the 14th Amendment is so multifaceted in its nature. The first part of the 14th Amendment that is important for AP U.S. government students to know is that it clearly defines what it means to be a citizen in the United States. The ratification of the 14th Amendment in 1868 was a direct response to a very controversial Supreme Court decision that had been made a decade earlier. That case was known as Dred Scott v. Sanford. In the case, Dred Scott, a former slave, was applying for his freedom after the passing of his master. The Supreme Court of the United States, under Chief Justice Roger Taney, actually ruled that Scott had no basis for bringing a case to court because he was not technically a U.S. citizen. The 14th Amendment helped clearly correct this and define what citizenship actually meant in this country. The next facet of the 14th Amendment that students should be familiar with are the two very distinct clauses at the end of the 14th Amendment, the first of which is known as the Due Process Clause, and the second is known as the Equal Protection Clause. The Due Process Clause actually protects every American's right to a fair trial if they are accused of a crime, while the Equal Protection Clause was put in place to make sure that all of our rights were being enforced equally, regardless of race, gender, or religion. But look closely back at the middle section of the 14th Amendment. It says something quite profound. It actually says that no state is able to make or enforce any law that abridges the privileges or immunities of anyone in the entire country. It also then goes on to say that no state has the ability to deprive anyone of any of those liberties that are in the Bill of Rights. This is extremely significant because it nationalizes everything that is in the Bill of Rights and makes it applicable to all the states. Those words in the 14th Amendment would become a huge point of debate and contention for politicians and Supreme Court justices moving forward. It is what we now know as the Incorporation Doctrine. It is also referred to sometimes as the idea of selective incorporation. The idea behind the Incorporation Doctrine is that everything that is in the Bill of Rights is now applicable to all the states because of those words inside of the 14th Amendment saying that no state has the right to deprive anyone of any of the liberties that are found in the Bill of Rights. In many cases in the early history of our nation, states tried to deprive people of fundamental rights, claiming that because those rights were not in their state constitution, they didn't have to provide them. The Incorporation Doctrine inside of the 14th Amendment makes it very clear that all of the rights given to us in the Bill of Rights are applicable to the states through the use of the 14th Amendment. As previously stated, there have been many instances in our history of states trying to deny people fundamental rights in the Bill of Rights simply because they claimed that it wasn't in their state constitution. These were cases in which the Incorporation Doctrine came out and was used strongly by the Supreme Court. The first case of real significance pertaining to the Incorporation Doctrine is the case of Gitlow versus New York. This was a case in which the state of New York tried to censor free press in an article written by Gitlow. The state of New York claimed that Gitlow didn't have freedom of the press because it wasn't in their state constitution. The Incorporation Doctrine makes it very clear that freedom of the press is granted to every citizen in every state of this country. The previously stated Mapp versus Ohio case uses the Incorporation Doctrine, but uses the case of illegal evidence being obtained against a defendant. Two other cases that students may want to know related to incorporation also deal with due process. One of which was the case of Gideon versus Wainwright, which established the idea that the right to counsel should be given to every American regardless of their income. The other was Miranda versus Arizona, the case that established the idea that every citizen should be informed of what their rights are at the time of arrest. While cases like Mapp, Gideon, and Miranda dealt most exclusively with the due process clause of the 14th Amendment, there are several other cases that are talked about that deal most exclusively with equal protection. The 14th Amendment's Equal Protection Clause has been expanded in several Supreme Court decisions to include what we now consider an implied right to privacy in this country. There are two U.S. Supreme Court decisions that deal with this implied right to privacy. The first of which was Griswold versus Connecticut, a case in which the Supreme Court shot down the state's ability to deny a woman contraception. In a related case in the following decade, Roe versus Wade cited that the implied right to privacy was the basis for a woman's right to be able to obtain an abortion. Roe versus Wade has remained one of the most contentious and debated Supreme Court decisions in American history. The Equal Protection Clause of the 14th Amendment was put to the test most exclusively in a set of cases nearly half a century apart that tested the issue of racial segregation. The idea of separate but equal was established in an 1896 Supreme Court decision known as Plessy versus Ferguson. In this case, the Supreme Court of the United States actually ruled that racial segregation in the United States would be acceptable so long as separate but equal facilities were offered. This would be the basis for legalized segregation in the United States for the next half a century. In Brown versus the Board of Education in 1954, a unanimous Supreme Court decision reversed the Plessy decision. It became the basis for desegregation of America's public schools and established the precedent that separate but equal was in fact not equal. Despite the amazing efforts of Attorney Thurgood Marshall and the NAACP in the Brown versus Board of Education case, old habits did not die hard, particularly in the American South. Resistance to change was major, including many public schools in the South encouraging their students to leave the public school system in favor of private schools in which the Brown decision would not have to be enforced. There were several major issues that would ensue in the coming years following the Brown decision, the first of which took place at Central High School in Arkansas, in which the Little Rock Nine, the first 9 African-American students admitted to this public high school, had to be escorted in by armed guards sent by President Eisenhower. Just 6 years later, at the University of Alabama, Governor George Wallace tried to prevent the first group of African-American students from entering the University of Alabama. The history of segregation in the United States is a long and storied one that has actually come in two forms, the first of which is known as de jure segregation. This is segregation that is made by law or force. This, of course, was the type of segregation that was imposed in the southern part of the United States, in which laws known as the Jim Crow laws were put in place, requiring the separation of its people by race. Jim Crow, of course, was a fictional depiction of an African American used with animalistic type of features to try to dehumanize African Americans in this part of the country. In the North, however, it was de facto segregation that was used. This is segregation not by law, but actually by practice or reality. Attempts to disenfranchise, that is, deny the right to suffrage or right to vote, has been a very difficult issue and a struggle for African Americans in the history of this country. Following the passage of the 15th Amendment of the Constitution, which granted African American men the right to vote, many southern states set to work on ways to disenfranchise these voters, as they were fearful that African Americans would fill the state legislatures with members of the opposing political party. Some of the tactics used to disenfranchise African American voters historically are the creation of poll taxes in which people would actually be charged for their right to vote. This was of course later abolished by the 24th Amendment. The inclusion of the grandfather clause, which stated that someone's grandfather would have had to have been an eligible voter for them to vote, and the incorporation of literacy tests, many of which were far too difficult for freed slaves to be able to pass. Now let's step away from the issue of civil liberties and look at the issue of civil rights. Remember, civil rights are actually things that our government does to actually protect us. It's government involvement designed to actually ensure equal treatment for us. Some examples of things that Congress and the President have done historically to promote our civil rights include the passage of the Civil Rights Act, the Voting Rights Act, Title IX, which is also known as the Education Amendment, and the passage of the Americans with Disabilities Act. Perhaps no act of government in the history of the world did more to tear down racial barriers than the passage of the Civil Rights Act of 1964, signed into law by President Lyndon Johnson. This groundbreaking law banned public discrimination by race, gender, and religion in the United States. It had several components that it focused on, including gender and employment and educational opportunities. It was one of the first major federal acts to target sexual harassment, and it included a major stipulation about employment and education that we now call affirmative action. Affirmative action, which has become a very controversial policy, is a policy in which employers and universities must document their attempts to admit and employ racial and ethnic minorities to their area of business or their educational facility. The constitutionality of affirmative action has been called into question by many in the political arena, some of which claim that the actual policy could lead to reverse discrimination. One of the most popular cases to question the constitutionality of affirmative action was the 1978 Supreme Court decision of the Regents of the University of California versus Bakke. In this decision, the Supreme Court actually upheld the constitutionality of affirmative action. However, they did claim that racially driven quotas, in which a predetermined number of students are set aside strictly on the basis of race, is not constitutional. Continuing from their momentum of having passed the Civil Rights Act in 1964, the following year Congress passed and President Johnson signed the Voting Rights Act of 1965. This groundbreaking federal law banned racial discrimination at all polling places across the country. It opened up doors to voting for all racial and ethnic minorities. It targeted such obstacles as the grandfather clause and the literacy tests, making them a violation of federal law. Universal suffrage rights were extended even further by the adoption of the 24th Amendment. The 24th Amendment strictly prohibits poll taxes from being charged as a requirement to vote. In the wave of the feminist movement of the 1970s, Congress took action in 1972 by passing the Education Amendment, also known as Title IX. Title IX banned gender-based discrimination for all educational opportunities. This included athletic opportunities in schools, as girls were given the opportunity to try out for traditional male sports, along with having their own female sport programs. Drafted by Senator Tom Harkin of Iowa, the Americans with Disabilities Act of 1990 was another monumental piece of legislation in the civil rights arena. The ADA prevents public discrimination on the basis of physical or mental disability. It applies to housing opportunities, educational opportunities, and opportunities in the workplace. It has become the basis for many of the handicap-accessible public facilities that we see today, including the establishment of the handicap parking process. The ADA is considered a federal mandate. A federal mandate is a regulation that is handed down by the federal government, and states are given no choice but to comply with these regulations. Some mandates are funded by the federal government, however, many of which, like the ADA, come unfunded, and the states have to foot the bill. Another prime example of a federal mandate was the Clean Air Act, passed by Congress and signed into law by President Nixon in 1970. The Clean Air Act was a mandate handed down by the federal government that made states comply with a certain standard for enforcing air and water quality. This includes the emission testings that many states do to this day on automobiles. It also led to the development and creation of the Environmental Protection Agency, another wing of the regulatory agency of the executive branch that oversees the enforcement of clean air policies. I hope that this review of Unit 2 of AP U.S. Government, Civil Liberties and Civil Rights has served you well. Good luck on the AP exam in May.